have for you today is an interesting case which some have described as the first transfer pricing case of South Africa. Not quite sure if that's correct, but there's something else here, and that is the case deals with ABD Limited. As you can see here is the decision from the Gauteng local division in Johannesburg, and it's all about brands. Now, what is funny about this, it is about branding, but I cannot find anything about ABD Limited. At least not in Denmark on Google. But let's see what the case is about. It's a good follow-up on the PepsiCo cases that we discussed recently, where we also talked about determining royalties. So let's see what was going on here. If we look at the facts, ABD is a South African telecommunications company with subsidiaries worldwide. These subsidiaries are operating companies with local shareholders, but having ABD as a significant shareholder. ABD licensed its intellectual property to these operating companies, from now on referred to as OpCos, in return for which they pay ABD a royalty. And the case at hand here is that SARS, South African Revenue Service, says that these royalties were not high enough. The present case involves royalty payments made between 14 OpCos and ABD from 2009 to 2012. ABD charged all of them the same royalty rate of 1% for the right of use of its intellectual property. The extent of what that right represented is in dispute. The calculation of the royalty rate is based on two factors: the size of the profit earned by the OpCo from the use of the IP, and then how the profit is divided between OpCo and ABD, because the SARS followed a profit split method. SARS first relied on the expertise of Mr. David. For some reason, he got thrown out. However, during the course of the proceedings, SARS retained a new expert, an economist, Dr. Slate. In contrast to ABD's flat royalty rate of 1% for all OpCos over the entire 4-year period, SARS contends ABD should have charged a variable royalty rate depending on the country and the year in which it was earned. The fluctuations created by the adopting this approach are considerable. In one instance, the royalty rate has been below 1% for Sudan in 2011, while in another it should have been charged at 9.2% in Syria. And let's just look at this again. It says SARS content ABD should have charged a variable royalty rate depending on the country and the year in which it was earned, right? And if you look at the table that Dr. Slate produced, you can see Afghanistan 1.7% in 2009, it then 3.2 in 2010, which implies that the sales or the profits for 2010 must have been much higher. You can see Benin for 10 was 4.9. And the table goes on. You can see Rwanda at the very bottom for 2009, 9.2%, 2011, 1.8. Very wild swings. I mean, this would be quite an interesting project to administer if you were to do your royalties this way.
A 10-second commercial. If you want to learn more about international taxation or transfer pricing, or treat yourself to an all-round update, or if you want your team to learn or stay updated, please visit my online courses.
If we look further at facts and witnesses, ABD makes a point that ABD has no incentive to charge its OpCos a lower royalty to avoid paying higher taxes in South Africa. A table in the record sets out marginal rates in both South Africa and the jurisdictions. This shows that for most of them, the tax rate in jurisdictions where the OpCos are located were equal or higher than the South African rate, right? So I'm not 100% sure what this argument is supposed to say, because ABD was not taxable in these countries on royalties except for withholding tax rates. It was taxable in South Africa. And to the extent that it could have eroded the royalties by higher rates, higher royalty rates, that would have worked because the tax rates in many of these countries were equal and higher than the South African rate. I mean, maybe the judge just got confused in the way he wrote up the facts here. But then it was argued that there was a further disincentive to undercharge the royalty. ABD has minority shareholders of most OpCos. If it were to undercharge the OpCos through the royalty, this would mean it inflated the profits of the OpCos. And that is a very fair argument, right? I don't know whether ABD held 90% or only 40% of these foreign subs, but to the extent it held 40%, I mean, it would have given 60% of the benefit to the other shareholders. The other thing that I'm surprised that they do not argue here is, there are other shareholders involved. If ABD overcharged, the other shareholders would have complained, right? So these maybe the South African transfer pricing rules take arm's length principle only from as low as 25 or 50% ownership in the company that you charge, but still these are considerations to think of. I mean, the other shareholders would complain. And then the judge starts talking about the witnesses. And he says, four experts testified about what the appropriate methodology to be used was. Now, it's a little bit like PepsiCo, where we have all the different methods, right? And conversely, what was not acceptable. Testifying for ABD were three experts, but they relied on different methodologies. Two of them, Mr. Bryan and Ms. Sana, testified the royalty represented that of an arm's length transaction using a method known as transactional profit split method. Interesting. And I'll explain later what this method means. However, a third expert, Dr. John, employed what is known as a comparable uncontrolled price method, or CUP. Ms. Sana gave supporting evidence for Dr. John's CUP application as well. And this is what the case turns about, is whether Dr. John's CUP is going to be better than Mr. Slate, who represents SAR's profit split method. So let's have a look at Dr. John's CUP. Dr. John went through the OpCo's history and identified the transaction he considered an internal CUP. The transaction involved ABD's sale of a Cypriot subsidiary to a third-party company, C, on 15 July 2018. On 3 September, in other words, 3 months later almost, the parties concluded a brand license agreement. This license agreement took place at a time when Cypriot's entity was independently owned. The license of the brand was for 3 years to company C, but C could terminate it at any time with immediate effect. Dr. John makes the point that the Cypriot agreement is an internal CUP. Dr. John's evidence is that a CUP is superior to other methods and an internal CUP is superior to an external CUP. And he quotes these paragraphs from the transfer pricing guidelines. But SARS questioned if the Cypriot transaction was a reliable comparable. SARS asked Dr. John if he considered certain comparability factors, and Dr. John conceded he did not, but he said that these factors were not relevant in all situations. He also acknowledged that there were differences between the intra-group license agreements and the Cypriot one, and he was asked if he measured him. He said he was unable to do so, and it was put in front of him that this CUP was not a useful comparable. However, both Slate and John defended their positions very strongly, and Dr. John insisted that the Cypriot agreement was still an appropriate internal CUP. Most differences were irrelevant or not material. To the obvious criticism that he could not measure, that if he could not measure them, he could not know whether they were material, he had two responses. The first was he stressed that the distinction between the asset value of an intangible and the royalty rate are two different things, right? And some of the differences influence the value of the asset being licensed, but that doesn't mean that it influences the royalty rate. That is his first argument. On the measurability challenge, Dr. John relied on Royalty Stat, the well-known royalty database. Based on his experience of this database, the differences were never material in royalty agreements. So he says, if you look at all the royalty agreements across the line for particular things, the differences do not influence the rates that much. Thus, he gives both a theoretical and an empirical response to the criticism of the Cypriot CUP. And the judge likes this. Right? Ms. Sana dealt with two comparability issues, exclusivity and duration. The Cypriot agreement was exclusive, while a lot of the others were not, and it was for 3 years, while some of the OpCo agreements were for 10 years or indefinite. She testified that normally exclusivity commands a higher price since it allows more market power and influence, right? So if Cypriot got an exclusive license, then it would have asked more than for the subs who did not have an exclusive license. But like Dr. John, her view was that in practical terms, exclusivity does not have a material impact on price. She testified that duration does not have a material influence on brand value and hence the royalty. She also offered a rationale. She said longer agreements meant less risk for the licensor and hence justifies a lower royalty, i.e. even less than 1%. So the fact that the intercompany royalties were longer than the 3-year Cypriot royalty only argues for them being even cheaper, right? She supported Dr. John's view that the Cypriot CUP is an internal CUP. Dr. Slate, on the other hand, argued that the Cypriot agreement was not was led with an independent entity because ABD Cypriot historically was an ABD OpCo. But when the IP agreement was reached with the company ABC, ABD, the Cypriot OpCo was under the latter's control and not ABD's, right? So the court simply says, you know what, you need to look at the time when the contract is concluded. And the fact that it is concluded with a party that owned you 3 months before that, it doesn't mean that they have influence over you now still, right? And I think generally that is right, correct. The test for when the enterprise is considered independent must be at the time the IP agreement is concluded. And the judge comes to a conclusion and hands the case to ABD. He says in his final conclusion, the Cyprus Cup proved to be the most persuasive of the different methods. The guidelines suggest that this is a preferred method. The facts of this case bolster that proposition. The two applications of the transactional profit split method yielded widely different outcomes. The Cyprus Cup most closely resembles what would be achieved in a market-based arm's length negotiation, and the criticism saying certain factors such as exclusivity, duration, and territory might lead to a different outcome is not that relevant for him. He says speculation does not amount to refutation. It's quite a nice sentence. I like it. To Dr. Slate's method, and I describe it in relative detail because it's interesting, but it gets thrown out because it is not standard transfer pricing methodology, right? But let's look and see what he did. Dr. Slate set out use of a methodology which calculates the incremental price consumers are willing to pay for a brand. So the WTP, willing to pay for the brand, right? To determine the ABD brand value and arm's length royalty, he used the WTP technique. He developed a survey in which ABD customers, and the judge was very impressed with the survey and the work that went into it, were asked about their preferences for the ABD brand versus a hypothetical entity. He developed a hypothetical new entrant called Telegreen and tested this against the customer's willingness to pay a premium for the ABD brand. The survey was based on responses from 2,700 business to consumer companies and 1,245 business-to-business customers from 6 markets: Cameroon, Ivory Coast, Uganda, Benin, Ghana, and Sudan. So clearly ABD is big in Africa. And the survey showed price premiums of 35 to 80% for B2C market and 24 to 52% for the B2B market. There are a lot of interesting facts about these numbers already that one can wonder about what lies underneath them, right? I assume the numbers are correct. I'm just wondering what drives the differences between the B2B and the B2C market. And cases like Unilever, Kenya, and cases like that come to mind when one considers this. He isolated brand value from non-branded value. It was necessary to do so as the opcos also sold phones and stuff like that. His next step was to calculate the brand revenue, i.e. the price premium earned by selling the ABD brand. The price premium was the difference between what a consumer would pay for an unbranded service versus for the ABD branded one. He performed further calculations with the WTP data to get a weighted price premium. He then considered the costs attributable to the brand and used them to determine the contribution made by each party. He used this relative contribution to set this profit split, right? So he looked at the overall profitability. Then I said, okay, so we're going to do a contribution split here. Let me see how much cost you spent, and let me see how much cost you spent, and then we'll split that rent based on the cost that you spent here, right? He did this for 14 opcos over all the years, and it led to variant rates from 1.1 to 6.7%. So this is different from the table that we saw that SAS produced, right? The most significant critique of Dr. Slate is that he assumed that ABD licenses included goodwill. So now we come to the critiques of Dr. Slate's case, and he made a number of mistakes, which is why the judge did not follow his thorough calculations. The error influenced the survey questions for the WTP option. So first he assumed that there was goodwill in there, and then he asked the surveyees about the goodwill. But the opcos didn't include goodwill. That was very clear from the royalty agreements, as the goodwill that would be redound to their benefit is something that they develop from their own effort. So I think what the judge is saying here is, you know what, the goodwill that was created by these local opcos within the local market with their local customers. It is something they didn't need to license from ABD. So this is quite a big hole in Dr. Slate's argument. This error then infected the survey, as is clear from several questions which contemplate goodwill. Their answers reflect on the opco's efficiency. It does not reflect on the license rights. This was not the only criticism that ABD made. It was, ABD argued, bias from the manner in which the questions were framed. And then they list a number of questions that the Dr. Slate asked the recipients, but he would only give them limited choices. So for instance, the option of, and I'm quoting from my head here, this doesn't matter, or no, this doesn't concern ABD specifically, was never in one of the answers. So you don't know if they would have picked that answer if they had the choice, right? A further criticism of its reliability is that the survey was performed in 2020, yet the respondents had to indicate what they might have done in 2009 through 2012. Now, I think this was a strategic mistake of Slate. You could also have done this maybe for 18 to 20, right? And get the same theoretical answers. 40% of the respondents were teenagers then in 9 to 12, and they may not have been too young to have a phone, or if they had one, to pay for it. So they wouldn't know. So these questions had to be thrown out for that reason. ABD also challenged the way Dr. Slate applied the profit split method. And here comes a very interesting aspect of the case. ABD argued that he used revenue, not profits, to calculate his royalty rate. Now, I haven't seen these calculations, so I don't know quite what they mean, but ABD argues that they ignored the OPCO's increased costs going with using the ABD license. So, such as requirement for better service, better looks for the products, etc., etc. And the judge goes on to explain a bit. He says Dr. Slate's relies on a methodology that is unorthodox and outside of the mainstream approaches, because you don't see this type of approach in transfer pricing, where everyone agreed with in the case. The court asked him if the WTP methodology had been used previously in the transfer pricing case. He was not aware of it, but he said he has been using it for many years in dealing with tax authorities. So woe to the taxpayers who had Dr. Slate on the other side. He also cited its usage by the UK's Competition Commission regulator, and this was before, right? But then the judge says, but the usage by a competition regulator is from market definition. It is not to deal with a transfer pricing problem, and you can see where ABD is coming from, right? If this is a method used for competition law purposes, that is about cutting up the market and manipulating the market. That is not about putting costs in low tax jurisdictions in low tax high tax jurisdictions and profits in low tax jurisdictions, right? So they are very different things. And then we've looked at paragraph 111 before, but the judge also says here, with regard to Dr. Slate's method, he says the criticism of Dr. Slate's approach has a solid factual basis. Its assumptions, legal, economic, and accounting has been dismantled by ABD. If this were not enough, it is an untested methodology for use in litigation in transfer pricing cases. And the Dr. Slate's approach gets thrown out by the Johannesburg court. We will see if SARS will appeal this case or not. But there's one last interesting point about this case that I want to point you to, and that is that when the judge considered Dr. Slate's approach, he applied something called the Dauber test, right? And the judge says the Slate said he used the WTP for 15 years, but since no one else does, we need to be very careful with this approach. And then the judge says, in the well-known US Supreme Court of Dauber, where the court deals with admissibility of expert testimony, the following test was developed to consider if an expert's methodology was valid, right? And this was in jury cases, but I don't think that's relevant. A, has a technique or theory been tested? B, has it been subject to publication and peer review? C, is it known, or does it have a known or a potential error rate? D, are there controlling standards and can you show their existence and their maintenance? And finally, E, if it attracted widespread acceptance in a relevant scientific community, such as the transfer pricing community. And the judge concludes, here is where the Daubert case comes from, and he says, while Daubert test is used by US courts to decide whether expert witnesses should be admitted in a jury trial, which is not what we are dealing with here, it is still a useful test to apply when considering the weight which should be given to the acceptance of a novel methodology. And I totally agree with him. What the WTP methodology was used by a competition regulator for one purpose does not signify widespread acceptance by the TP community for TP purposes. And I think this is an interesting test or list of questions that the Daubert case applies, and I'm sure we can use it elsewhere in transfer pricing as well. I hope you enjoyed this case, and I look forward to us discussing the next case next time. Bye for now.